you will have their NHIF, you have their PIN, and we know that we even extend beyond that, and especially through the document we have as a biodata form, you will equally have information to deal with people's family, including who is your next of kin. Others run medical insurance, and therefore you'll go on and ask spouses details. You will ask details about their children. A good number of our companies also deal with clinics, or they have in-house clinics. And therefore, when you're there again, you're dealing with now this is actually under the Act referred to as very sensitive personal data. And this is information about someone's medical health. So you will find pursuant to your HPV AIDS policy that you might be having data about employees who have this kind of a condition.
This.
Bill, I think there's some noise somewhere. You can mute everybody.
Yes, I hope that is addressed now. Yeah, we are saying for some who also run medical facilities, and even those who don't have medical facilities, inevitably you have to deal with applications for sick off, meaning you also get information about details of illnesses of your employees, sometimes even their families. And you realize without the data protection policies, some of the questions maybe that we do ask employees is, where were you yesterday? And the employee will tell you I was unwell. And most likely you'll find that what we ask next is, what was the problem? Ulikuwa mgonjwa wapi? Now, you realize now at that point, with this act, you have already delved in what is protected by the Constitution and under the Data Protection Act, because this employee is not obligated to disclose their medical condition. If it is a lady who is telling you my child was unwell, again, you have no legal authority to inquire what the child was ailing from. And we're even talking about basics of what documents you ask for them to justify sick offs, because there's if a document that an employee contains personal data that may disclose their conditions, then that is private and they cannot be compelled to share with the employer or any other person. So ideally, this is the personal data that you're talking about, a data that is unique to an individual. And I hope everyone in attendance at least is able to get the definition on how to distinguish personal data from any other form of generic data. Some other terms that you're going to be coming across is data controller or data processor. And again, as introduction, just to answer a lot of questions, which I know we'll touch on, the data controllers and processors, it's good to understand according to the Act what are these people or entities. And it is first of all important to know, even before we know who is a controller, data processor, classifying them maybe in terms of gender, in terms of date of employment, in terms of ethnicity, in terms of the region. So whether what you're doing is just to pick that NHIF card given to you by a new employee, you feed it to your computer, then you are processing. The moment you also put in the ID number from the ID, you're further processing. The moment you now again have to link it to a bank account, and then you have to link it to all that, you are processing. if you store that information in your hard disk, you're processing. If you share it with the bank or any other party, then you are processing. And therefore, in that case, who is a data processor? A data processor would become now that person or entity, that person or entity that will now be carrying out the processing activity on behalf of that entity that would have given them instructions. And in this case, and from the onset, mainly most of these person giving instructions to process is what is referred to as a data controller. And that again, let me just for clarity, highlight on that maybe through examples. That in this case, company X, who maybe is an employer, company X is an employer. And as an employer, it means it is that company that determines what data means and the purpose of processing. It is this company that will determine, for instance, you as the HR manager acting on behalf of your company, it is a company that will determine what data you need from this prospective employee or even a visitor at the gate. So you tell a visitor that you need to register your name there, your phone number, your car registration number, and so on and so forth. So in this case, if you are the X company, then you are the data controller. You are determining which means, and means here, in this case, it could be electronic. You could have people feeding into maybe even biometrics, or you could even have information captured manually or entered into some gadgets, wherever. So you are the ones who are determining what data you need from this visitor or from this employee. You are also the one who will determine means and the purpose that you process, meaning whether you want to key in into your systems, whether you want to transfer it maybe to the government or to the banks or to the SACCOs. In this case, you should know that this company is the data controller. And to make it easy, all organizations of the persons represented in this setup are data controllers. And in this case, I'm saying all those organizations that you represent are data controllers by default, because they are the ones who determines what kind of data is collected for its purpose. But when you go to a data processor, it is possible that, in fact, you'll find that most data controllers are also data processors. And maybe to just give an example where the two must not, one must not relate to each other, and maybe just to give an example, assuming you're using biometrics. In which case, the company, which is now X Limited, and you have said in this case, X Limited, since it is the one that is determining data that will be collected from visitors and its employees, we have said that is a data controller by default. But you may find that this data controller may not have the ability to do some form of processing. And an example is biometrics, for instance. So company X will contract company Y for the purpose of the biometrics, getting the biometric data and giving it in a way that is processed for company X use. In this case, the company that is supplying the biometrics is purely a data processor. And why it is purely a data processor is because it does not determine, it is actually given instructions on what to collect. It is told specifically, come and install biometrics. It is specifically told, come and install tracking devices on all our vehicles and give us data about their locality, the consumption of fuel, the speed. So in this case, the company that is installing and keeping or processing data about those vehicles is purely a data processor. I know this is always confusing, even when you're dealing with a physical one-on-one, but I'm hoping that with those examples, in a nutshell, is that almost, let me say, every company, and in this case, let me use the word employer. Every employer in the company is a data controller. And this data controller may have engaged several data processors. Please note that if you are employed as an agent of the data controller, you are not a data processor. For instance, if you are the HR, and therefore you are the one keying in the data on behalf of the company and putting it into this Excel sheet and sharing and all that, take note that you are not a data processor. The data processor is, in this case, your company, because it's the one that is determining and you're just an agent. The same to accountants and all that. If you are employed by a data controller, then you are not a data processor. You are in essence doing processing activities on behalf of the controller who is the company. This will become clear because when we come to registration, then the Act provides the registration of data controllers and data processors. In a few, part of what will be the compliance part of this with this presentation or this short presentation would be to note that one of the requirements is that you must have a data protection policy. As you do the registration, which is mandatory, you must have a data protection policy, and this data must comply with the principles of data protection as enshrined under the Data Protection Act. There are 7 principles that are universal. So as you come to formulate your policy, and for the purpose of registration, you must ensure that your policy pays tribute to each of these principles. And in a nutshell, I can just mention what each of the principal points to or talks about. And the first one is where you're tasked to ensure that if you're processing or carrying out any data activities, then you must do it lawfully, fairly, and in a transparent manner. Lawful means that ask yourself, if for instance, let's take an example of processing. And in this case, we use sharing, which I know is the most common form of processing. If you want to share data belonging to the owner, maybe so that you understand better, the person who is being identified by a certain set of data is referred to as the data subject under the Act. So, for instance, the person who is identified by that photo or by that email address or by that ID number or PIN is the data subject. And in this case then, if you need to share information that you have collected from your data subjects, in employment setup, let's use if you have the information you have collected from your employees, because the data belongs to them, then if you need to share them, you must always ask yourself, what is the basis for sharing? Because remember, this is data protection. Protection means you cannot arbitrarily share information about someone without their consent, without their authority. And therefore, your policy has to guarantee them that you only obtain and process information about your data subjects in a lawful, fair, and transparent manner. Lawful means it may be sanctioned by the law for you to share. Like for instance, in HR, we share information with maybe NSSF, we may be required to share with the National Employment Authority and KRA and so on and so forth. In that case, you are sharing it lawfully, and therefore you are not in breach of the right of an employee. Then if however, some information that you're collecting from the employee is not dictated by the law, then the aspect of where you are taking it and how you intend to use it comes to fore. For instance, you have you have bank accounts for your employees. If you ask me whether it is a legal requirement that you must pay people through the bank, I will tell you it is not, because the law says you may pay in any forms, including checks, and including M-Pesa and even cash. But maybe for your reason, and maybe for safety and security, you want you to ensure you pay your people through the bank, and therefore you ask them for the ID, which is a personal data. If they give it to you, you will have to commit why you are asking it and not use it for any other consistent or inconsistent reason. And that ties up to the second a principle there, which is purpose limitation. That when I give you the information, then you should know the information I've given you is clearly limited to what you asked me for. So you asked me for a bank account. It must be purely for processing my salary and nothing else. You have no right to call my bank asking about my financial transactions and all that. If you're doing that, then you're failing the test upon which you asked. It means you are not fair, you are not transparent. You asked for the account to pay my salary, but then you're using it for another reason. Purpose can also be illustrated maybe when you ask someone for the details about their family. And the question is, why are you asking details about my wife or my husband or my children? And in this case, you'll be saying the purpose for which we need details about your family is because you have a medical scheme. In which case now, the purpose for you obtaining that data is running a medical scheme for me. You are bound not to go beyond that. So the details I have given you about my wife or husband or some or whoever is in the family is limited to medical insurance. If maybe, and I know it happens so often when you find the employer calling the spouse, then you need to ask yourself, am I still within the purpose? Am I now going beyond? What was the reason that this person gave me details about the phone contact of their wife? So ask yourself that once a data subject gives you information, you have explained fairly and transparently the purpose for which you are obtaining it. Okay, and you should not at any one time violate the consent that was granted to you by sharing or using the information beyond the scope. Data minimization, ideally, should find your organization as you're coming up with a principle that don't collect excessive data, because under the law of this, under the Data Protection Act, if you are obtaining excessive and unnecessary data, then you are violating the law by the fact that the possibility of these excessive data being kept at your premises means that there is a huge likelihood that they could leak out there and harm people. So data minimization is only keep information that you need for your purpose, that you genuinely need for your purpose. Any excessive data is a danger to the organization and is also a danger to the data subject due to the huge possibility of it leaking out. In short, before you ask employees information about their spouse, ask yourself, is it necessary that you must have information about people's spouses? Is it a requirement of the law? No. What is the purpose? It is a medical scheme. Do you have a medical scheme? Yes. Then can we limit the use of that data to medical or administering the medical scheme only? That is data minimization. But we find in many organizations, we have got so much data. And you ask yourself, for instance, if you come at the gate, the very first, you'll find a big book and a very old black book kept by the security guy there, which is also, you can imagine how after being used so many times, it's even in tatters, very old and sometimes just placed there without any kind of security or safe storage. And you ask yourself, how much data is inside there? There is data of all the visitors to the company throughout the year, including their name, including their phone number, including their car registration number, and so on and so forth. You do know what you ask. Now, if you ask me today, what is the purpose of that information? Then you need to interrogate each line of the data that you are asking and find whether it is very important and whether it is pegged to a very specific purpose. And after that, you look at the at the principle of storage limitation. In which case, here we are also asking, assuming there was need for you to take my details as I access the workplace. And maybe in this case, the whole aspect is security. So I have signed in with all my details. There is even a CCTV camera running up there. And then immediately after that, I sign out when I'm leaving and I'm cleared to leave. My vehicle is checked, kila kitu, and I'm allowed to leave. The question is, how long do you still need to keep my data? Storage limitation. How long do you keep your employees' file? For how long? What is the requirement? Is it a requirement of the law? If not, if an employee left 5 years or 10 years ago, where do you still have their file? You are not observing the principle of storage limitation, neither are you obtaining following the principle of data minimization. And therefore tomorrow, if there is an audit on how you handle data belonging to people, you will fail on this test and you may find yourself being on the wrong side of the law. Remember, the whole purpose of this act is to ensure that the data, personal data that is obtained, is kept on the minimum, is stored for as long as it is useful, it is shared as long as there is a transparent and fair reason that may be pegged on the law for sharing. And most importantly, if you must have it, because we appreciate some of the data must be kept, must be stored by the employer through provisions of the law, then the next question would be, how are they stored? What is the integrity of your system, storage system, be it for physical? How easy is it for a person to just access your office and ask you for a personnel file belonging to an individual? So you have, and that is maybe for the physical storage. Ask yourself, what about the electronic storage? How easy is it for me to come in and copy some data belonging to all your employees? How easy is it for me to get hold of a printout of your payroll? And I want to believe in that printout, I'll be able to get details about people's account numbers, their names, their IDs, and a lot of other details that you know are matched in there. And the misuse that you're talking about here is like, for instance, if I can give a basic example around the election period here. I'm very sure as many as those represented in this forum may have received a text message from politicians. And you might have wondered, this politician has your number. This politician refers you by your 3 names. And this politician knows that you are a voter in a certain ward or a certain county or constituency. Did you ask yourself how this information came through to that person? If you did, that is a pure case of breach of personal data. It means there is someone you shared that data, but they used it for the purpose not intended. It could have been your M-Pesa guy who you gave the information for purposes of a transaction, but then they did not limit that information to that purpose. And therefore, what they did, they sold it to another guy who went and sold it to the politician. And after you did, the politician now fed it to a bulk SMSing system. And before you know it, there is this politician reminding you to go and vote. And you ask, how did this guy get my number? That is a typical case of breach that is meant to be attended by this Act of Parliament. Having said that, I will also in a nutshell also provide, or rather talk to the rights that this Data Protection Act guarantees data subjects. Like I said, a typical example, since this is an IHRM forum, a typical category of data subjects are your employees. So under this act, your employees have a right to be informed. And this should be a radical transformation about what is the practice in most companies now. You just find, assuming he's a new employee, you just find when they come in at the point of recruitment, they'll be directed to a certain desk. And once they get there, I'm not even sure there is a cordial kind of greetings and making someone to be easy. But the next thing is, umeleta kitambulisho, nipatie copy, nipatie NSSF, nipatie NHIF, nipatie PIN, nipatie account equity. You will find that we do what we've been doing before this law is ideally you feel like you are entitled to this information without seeking the consent and explaining to the owner of this information what you need to use the information for. Clearly, and in black and white, under the Data Protection Act, data subject has a right to be informed about what data is to be collected about them, how you intend to use them, how you store it, who you share it, who or which organizations you share their data with. So these, to as long as it is the right of the data subject, it becomes your obligation as the employer. The data subject, read the employee, has a right to access personal data. The information you are keeping in this file belongs to the employee, and therefore they have a right to access it. They want to know what set of data you have about them, what you are using it for. And according to the Act, if this person writes to you and tells you, I want to see my file, you must comply within a period of 7 days. You cannot charge, you cannot make or introduce a condition that makes it difficult to enjoy this right. And I know out of my interactions with HR practitioners in many companies, you find that we are allergic to this employee asking kupatiwa file yake. It's because we feel like that file belongs to us. But in the spirit of this act, whose file is that? Is it the company's or the employees? Clearly, if it contains personal data of the employee, it is that employee's file and they have a right to access it. You are just a custodian because the law allows or gives you a mandate to have the information as may be contained in that file. And in consonance with the right to access, then the employee may actually see that there is something that is in that file that is not correct. And in this case, an employee, the data subject, has a right to have information that is not true corrected. If that information is inaccurate, must be corrected. If it is untrue, you need to correct it. If it is outdated, you need to update it. If it is incomplete, you need to complete it. If it is misleading, you must delete it. And like you say, once you correct, you must come back to the employee or the data subject and give them evidence that you have since deleted or corrected or updated this. And this has to be done within 14 days. So again, that is a robust right for the data subject. Remember, for purposes of discussion, I'm just talking about data belonging to your employees. But I say this Act of Parliament does not reside in employment. It is also about that visitor who you took their data, whether they are suppliers, whether they are business contacts that came through that gate. As long as you have their personal data, the same rights applies to them. And maybe here is a typical case when I say right to correction. I was having this case, or rather, in some of the discussions about the compliance with this act, where an employer was, in essence, saying, like, for instance, an employee comes to you and they want to have the data about their spouse changed. And they are telling you, this guy, tuliwachana nae, and I want you to substitute. This is no longer my wife, substitute with this, or this is no longer my husband, substitute them with this. Is the typical case that is being envisaged. that you must have a policy that makes it free for them to come, access to see who is this person who I may not remember when I was employed, who I indicated as my next of kin. And these are typical cases. You may find at that point someone was not married. They indicated their next of kin was their uncle or their father. With the time, maybe that uncle or father died, they need to update. With the time they got married, they want to put in the spouse. With the time, they don't even want to see the spouse to be there. They want to put in the name of their child. You're being told, facilitate this process. They have a right, because it is against the law for you to keep inaccurate information, that your biodata reads that someone is single, yet they have been married. Or the converse is also true. When they recorded, it is captured as married, yet this employee has since divorced or they have since been separated. In short, if you must keep information, keep it accurately. Sometimes an employee may feel the information they may have given you is no longer relevant. Like for instance, you may have said you wanted it for medical scheme and you no longer give this medical scheme. Then clearly I'll tell you, can you now remove this? It is no longer relevant. And you can only decline to delete if the information that you're being asked to delete is required by the law to be kept by you. And you must give a justification. Also looking at right to erasure, I'll just read that together with the right to deletion, right to portability. Yeah, right to portability under this act refers, for instance, when a data subjects want to move a copy or a set of data from organization A to organization B. If you want to change your bank from ABSA to NIC, under this act, you do not need to go and give a whole set of data to your new bank. Why? Because the bank, you are assuming it is ABSA. It has your photo, it has your email address, it has your PIN details, it has everything. So why does NCBA need to keep those documents? Yet I have stopped banking with them. Under the right to portability, you can just tell NCBA, I have since closed my account, and with this instruction, can you forward all my data to bank X? That is a right of a data subject, and I want to believe. I am not saying it will happen, but I don't see why it shouldn't. If an employee is telling you that since they have quit working for you or you have sacked me, can you give all my information that you have about me to company X yenye ni jirani yangu, because I don't need to go and kutafuta hizi data once again. You have my PIN, you have my ID, you have everything. Can you have all this information given to the next? Ideally, this should be done without putting unnecessary hurdles. Don't put unnecessary hindrances, and don't charge unless you're saying it's a very reasonable charge. And this should be done within 30 days. Again, this just emphasizes how robust these kind of rights are. Therefore, what kind of policies we need to have in place to, in essence, just ensure that you give meaning. Your policy, for it to be compliant with the data protection, must pay tribute to all these rights of your data subject, in this case, your employees or the contacts of the business. For those who use automated means of decision-making, then the Act equally ventilates on it. And in this case, for instance, you're using biometrics, and therefore you use the biometrics to pay overtime. You see, in this case, you're not using a human interface here. You're just trusting your system. Now, under this Act, if you decide to automate, you need to have an alternate human interface or a backup human interface, so that if, for instance, your machine malfunctions, the employee or the data person should not be helpless and should not be left entirely to the decision of that machine. If you want to get access to a mall, and you have to get whatever token there and insert it so that you can get access, and for some reason it doesn't allow you to get in, you should not be left at the discretion of the machine. If it is about a computer-generated kind of stuff that makes automatic decision to you or about you, then if there is a complaint about the machine, then there must be a human backup to ensure that you do not suffer unnecessarily because of being subjected to a decision through a machine. Employees or your data subject can prohibit you from further processing their data. That is if they think you're not processing it in a fair way or you have started going beyond the scope or the limits that they had allowed you. Yeah. Also note that whenever a data subject is a minor or a person who has mental issues, then these people have no ability to give you consent. And therefore, you must give those consent through their authorized guardians, so that it is not allowed for you to say that this person gave me consent to share, and yet the person you're talking about is a minor. Again, quickly, I would just want to give a few highlights again as you purpose to come up with these policy on data privacy. There are exceptions, or rather there are exceptions when it becomes somehow difficult for you to get consent from a person. And these are the questions we keep getting over and over again, where you maybe have so many people or so many data subjects and you want to know whether it is possible for you to every time go seeking consent from each of them. And the exceptions here is, I just highlight the main ones. For instance, if it is a contract that you are getting into and there are some pertinent details that must be involved or must be shared, then in that case, you don't need consent, provided someone has signed a contract that knows some form of this information could be shared. And therefore, like for instance, you want a loan, you have signed that loan agreement and all that. It will tell you there's some information this bank must obtain from you, including the guarantors or the surety or whatever else you're giving. So this is the contract that you have signed voluntarily, and therefore, what flows from that contract, I must not come back to you for consent. Again, I had said lawfulness, if it is a legal obligation for you to share this information with the KRA or with the NEA, then again, you don't need consent from individual data subjects. If you're doing this in the interest of health and safety, emergency, that's what we call vital interest. You do obtaining this data in the interest of the data subject himself. Maybe someone is unwell, maybe someone has been through an accident, then clearly now to get some data from them or from their next of kin, you don't need consent. Public interest, if it is a public interest investigation, as you all know, then the same can be obtained from people without having to ask them their consent. We want identity of this person to be disclosed in either public interest, or if it is a public authority like the CID doing the investigation and all that. These are some of the examples that you're saying that you may not get individual consent from each and every data subjects. In terms of compliance also, you also need to know that the Act has a provision for a data protection impact assessment. And this is mandatory, and especially when you are carrying out some classified form of activities. One of it is high-risk activities. For instance, you are making automated decision-making, using CCTVs, you're using biometrics. Then in this case, you must have a DPIA. DPIA is as an environmental impact assessment, which, under environmental impact assessment, they'll be looking at the impact of your activities on the environment. Here, depending on what we do, the data protection impact assessment is meant to assess the impact of what you're doing on personal data belonging to people. So you want to know, for instance, if you are collecting all this information through the CCTVs, who accesses them, how long do you keep them, how do you destroy them, who has access? All these are meant to just ensure that whatever processing activity you're doing do not unnecessarily expose personal data belonging to Kenyans. There are some which are referred to as high risk. Yeah? High risk, and this may, when you have actually profiled, and I don't know, maybe you tell me from your end whether you have profiled your people into gender. So if I asked you, you have a category, these are male, these are female, these are people between this age and this age, these are people who are unwell, because you may find out of your cross-referencing, you know this person has consistently been unwell, you could even know they are terminally ill. So if you're also carrying out this, then we need to know how you are doing those processing, how you're storing your data to ensure that that information that has come to you out of your processing activity is secure and does not harm a Kenyan. And we are saying they are referred, they are categorized from high risk to very high risk, depending on what you may be doing. And in that case, you must carry out a data protection impact assessment. As we will find out, this is going to be mandatory with time as the Act of Parliament instruction. This is going to be another mandatory assessment that you must do prior to you starting. Remember, is prior to you, maybe for instance, you have decided you want to install CCTVs to monitor your 1,000 people. A DPIA is a must, right? That's just an example of what you're saying. You might find at the doorstep being asked this kind of question by officers from the Office of the Data Protection Commission. Every right comes with an obligation, and I think I had mentioned that when we spoke about the rights of data subjects, but there are also obligations now for the data controller or the data processor. One of it, you are supposed to register, and I have, in my introductory remarks, I had said you must register as a data controller or data processor. I think the deadline was time around April or May, not very sure about the date, but indeed, as we are now, all of the organizations represented by the team here should have been registered. And if they are not registered, you are committing an offense. And therefore, you need to be careful that once you have this recruitment done, which will be completed within this month or so, make sure you're not the first case study for enforcement of the or enforcement of compliance, because these people could come, or the officers from the data protection could come in and ask you why you haven't registered. Yet, like you said, for all the organizations and especially employers, where we are carrying out all these data processing activities, then you fall within those categories of employers or companies that must register. Okay, you are supposed through your policy to have what we call data protection by design or default. And in this case, a very typical example is whenever you're installing any system, whenever you're introducing any, whether it is sharing, processing activities that we may have alluded, key consideration is that you must have data protection by design. Now, if you have your payroll and you know it has a lot of data, then the question is, the way it is stored, is it protected? If it is through a laptop, does it have proper passwords? Does it have a limitation to access and who is authorized to get into those emails and the servers and all that? You're saying that it should automatically, the system installed should automatically protect against unauthorized use or sharing of personal data. That's what we call obligation on data protection by design. If I am auditing you, I will come to your organization, and maybe the first test I want to know is how easy is it for me to obtain data from your laptop or from the desktop? Can I just come and insert a flash disk and I'm able to download a file and just go with it without anyone noticing? In that case, it means you're keeping your data carelessly and you fail on this obligation. But if at all I was to come and plug in the memory stick and I'm told that that device is not allowed in that machine, or I must put in some passwords or access passwords, then I know by default you have protected against unauthorized access. So again, those are some of the things that you want to look at. I have talked about obligations on data protection impact assessment. So if I'm auditing you, these are some of the things I will ask you, whether if you're carrying out a high risk processing activities, I would want to know, did you carry out data protection impact assessment? And this is supposed to be done in conjunction with the Data Protection Commission, and they are able to guide you based on the activities you do, to guide you on controls that you can put in place, to ensure safety of the personal data. For those who have registered, they know that part of the requirement is for you to tell the Office of the Data Protection Commission the kind of controls you have put in place to ensure that data does not get compromised. And this is part of what you're saying can be brought forward by data impact assessment. Yeah. Something else that I also need to highlight also about your obligation, and this is also part of compliance, is that inevitably you find that you have to share maybe information about your employees with third parties. And the typical example is a bank. And here the question would be then, what kind of non-disclosure agreement do you have with the bank to ensure that the information you send to them is not used against the consent that was granted to you as the data controller? So again, if I'm auditing you, I look at, fine, you share information with the auditor. Where is your contractual, where is your contract with this person, and where does it ensure that you protect the data of your people? Whether these are auditors, whether these are, like you say, the banks, the circles, and whoever that you may inevitably have to share for many other reasons. We want to know whether you have contracts that binds them against unauthorized use of the data shared with them. Another obligation, again, under the Act, you note that if there is a breach, like for instance, all your payroll data has been compromised and someone has gotten unauthorized access to it. Under this Act, it is your duty to report the breach to the Office of the Data Protection Commission. In short, ni kazi yako kujishtaki kwa the Office of ODPC, and you tell them, look, we are keeping this number of data. And as you are registering, like I told you, you should have told the Office of the Data Commission what controls you have put in place to ensure that information is not lost, because you have to explain the circumstances under which it was lost. It might have been lost, stolen, maybe the computer was stolen, or something like that. And it is upon then the Data Commission can also be able to come and look at the risk, the people who have given you the data, and even recommend proper safeguard, but the same will equally be used to determine what kind of penalties that will be slapped on you. So you should notify the Data Commission within 2 hours from the point you become aware of the data breach. Okay. And on this, I'll just talk about cross-border transfer, and especially those who send information, maybe to the auditors across the boundaries, maybe the market. And I know this happened a lot during the COVID-19 period. Now, under this Act, you should be very clear that before you do cross-border transfer, you must first of all get consent from the Office of the Commissioner, so that they're able to give you what they call adequacy decision. You want to know that the right of Kenyans are protected even as you're sharing this. You must ensure, and it must be necessary to share data between Kenyans. And most importantly, what the office will equally be looking at is to ensure that the country that you're transferring the data to has proper protection measures for data safety. In short, we will want to ensure that that company equally has a data protection framework that ensures the data of your people shared with them does not get compromised at their hands. Most importantly, the consent of the data subject must be sought, because in some cases, the employee can tell you, or the data subject can tell you, don't share my data with that country at all. And if they tell you that, then the right must be respected. In winding up, I will quickly guide you through the registration procedure. Remember, like I said, this is mandatory. You should have registered by now. The registration is online. If you have all the data all the information that will be required. And also note that the kind of information that you give there will determine how you are classified, either as a low risk or high risk processor, controller, and the same will dictate the invoice that will be given for payment. So you're supposed to apply online as a data controller or as a data processor, or both, depending on the activities you do at your firm, which the office will do the verification of the application. Yeah, and as you do the application, given on the details that you give, you'll be given an invoice which you can pay, and they have several forms of payment, whether through the check, through the bank, or even M-Pesa. Which one you pay, once you pay, it is actually captured on the system, and they take the information next to verification process, where they look at all the data and the information you filled in there. And stage 3, they issue certificate of registration, which can be downloaded online. You don't need to go to the Office of the Data Protection Commission. And you remember that the same should be renewed in a cycle of every 2 years. And these, I don't need to go line by line on this, because depending on the organization that you are, these are some of the information that you'll give when doing your application. Of course, they will ask you the number of people you have, and they will also want to know the turnover of the organization. So it's a factor of the number of employees and the turnover of your organization. And you see, it will then be clustered depending on those 2 parameters. And they will have different banding based on whether you have between 1 and 50 employees, between 51 and 99. And when I say 1 and 50, it means even if you have 1 person who you have their personal data, you're still obligated to register, but the figures will be lower depending. Then there is 51 to 99, and then they will be above 99. Then the turnovers, we'll be talking of if the revenue is below 5 million, in some between 5 million and 50 million, and the other one above 50 million, which then they get to know how much to invoice you for. There are some organizations that must be registered mandatory, irrespective of whether they have these numbers or turnovers, and some of these are those that carry out. I think I can just have that in the next slide. So that for mandatory registration, irrespective of the number of persons you have or your turnover, if you are a political entity, if you're in the business of gambling, if you are operating CCTV systems, if you are operating educational institutions, health administration, hospitality, property, financial services, telcos, direct marketing, transport farm services, and processing of genetic data, then this is a must. You must register, because this is deemed to be a special category of the must registration under the Data Protection Act. If you don't comply, it's always important to know what are the consequences. And here is saying, if you don't do this, if you don't put in line this policy, you don't register, you don't carry out the obligation, as I have said, then you will find the Office of the Data Commission giving you enforcement notices. And this will be dependent on the default that you have. And they will give penalty notice if the same has not been collected. And you see, if the same involves basic breaches here, then you'll be talking about that you could be fined 10,000 for each penalty identified for each day until you clear or you comply. And in this case, for instance, let me give an example that they have identified that you have not carried out a data protection impact assessment, maybe prior to installation of your CCTV or something like that, or the biometrics. Then they will, the penalty here will be 10,000 per day until you correct. And that can be a huge penalty. But if it is generally the organization that has failed, for instance, there's some information or maybe the data for the entire company has been lost or shared against the data subject's right, then in that case, this fine will not be the one applicable, but at that point, it is usually a percentage of the turnover or quite penalties in millions to the organization. And this is coupled with legal prosecutions to the persons who would have been held responsible or liable to have ensured that the breach did not take place. If you're a household, you don't have to register. If you're carrying out some data in national security or public interest, you don't have to register. And if you have an order of the court of the law protecting you from such registration, those are the only three categories or instances that you may not register your entity by the law. That being said, perhaps I will be guided on how we will do the Q&A session. I purpose to share these slides to the officers of the chapter. And then we are hoping they will be able to circulate them to each of you. But in the event, and I know this has been quite a rushed kind of presentation, in the event you will need further guidance from us in terms of development of policies and the registration of your entities, then you can be ready to contact us at the number that is projected on the screen. So back to the conveners so that you can see whether there are any questions that I need to address in the next few. Thank you.
Thank you very much for the presentation. We have questions streaming in at the chat. If you can address a few of those.
Yeah. Yes, I can see a number. Let me just see whether I can address them in the order that they have come in. I know some of them may have been addressed during the presentation, but I'll just highlight. And like I said, if any member would wish, subject to your permission, the other end wish to ask the question clearly, then I can be able to respond to it. So I'm seeing more clarity. I think this is from Christine, and whether the registration online, if you can share more details on the online registration. Yes, on these, maybe what you need to note down, just go to your search engine and just search the Office of the Data Protection Commission. They're calling themselves ODPC. And from there, they will actually guide you through the registration process, where you have to register and then you go step by step in a guided process, provided you be grounded, you be firm that you know what you're keying in there, because the moment you miss some of those information, from experience, it has become very difficult to undo. And in some cases, you could find yourself being slapped with a very huge invoice based on the information that you give. Yeah, but there is a self-guiding kind of a registration portal under the Office of the Data Protection Commission. This is odpc.go.ke. After that, yeah, I had said I will share these notes, so that's not a problem. I've seen from Grace when the organizations need to be compliant, and the answer is by now you must be registered. By now, meaning you're already in default of the act and you could face legal consequences, and therefore it is an urgent thing that you need to do. Government agencies, yes, they are equally meant to register. I've seen this from Matthew. Actually, just to ventilate that, part of the reason we had to put these acts in place is because the government sought through the Huduma numbers. They wanted to collect data belonging to Kenyans, and they had to be stopped by the court. So yes, even the government itself, to the extent that it needs to collect, share, or keep data belonging to Kenyans that is of personal nature, they equally have a duty to register. Okay, yeah, Danson. I can see the query here is that most companies tend to ask for evidence whenever employees wishes to change their spouse. How legal is this in light of the DPA? Yes, I've always been asked these kind of questions, and I know sometimes we introduce impediments to updating people's data. Remember, we said an employee has a right to update, to access and actually update the data being held by the data controller. And a good number is in the case where, and maybe I need to change my spouse, maybe for purposes of NHIF and so on and so forth. I have seen cases where you ask so many evidence, and in this case, you're asking for evidence of marriage. You're asking for marriage certificate before you effect this. This is a barrier. This is a bottleneck to exercise of employees' right. And if you ask me whether it is legal, I would say it is not. Because once for our purposes, when we are employing people, we ask them to declare who their spouses are. We don't make it mandatory for them to give us their marriage certificate. So if a declaration worked for you to indicate someone as a spouse, the same declaration should be sufficient. The same declaration should be sufficient for you to update, so long as the employee signs and they're the ones who have told you, remove Jane and put Grace as my spouse, and they sign. That should be binding, and you should not ask, give me divorce proceedings from this one, give me now the marriage certificate to this one. Those are unnecessary encumbrances to exercise of legal right. Of course, in cases where we want to check something like insurance fraud, in which case, for a case like NHIF, you'll find an employee being told to do an affidavit. And even then, what is an affidavit? Again, an affidavit is a self-declaration, only that it is done before a commission of oaths. It is simply your employee saying that I want to make this oath and say that from today, Carol is not my wife and Grace is, and they sign, and the commissioner will just append a stamp there. So we shouldn't ask for a lot of evidence, and we should not extend our jurisdiction to even regulating personal affairs about our employees. Again, I've seen a query from Grace here, where during registration, what are key requirements? The first requirement is that you must have the registration incorporation certificate from your company, because it must have what we call a business registration number. That is key requirement that you should have even prior to starting. But then the other information is actually information. These must be uploaded. The certificate may be uploaded, or you just put in the business registration number, BRS. But like you said, once you get in, it is in form of you putting data based on the questions that they'll be asking you for different categories. And that way, you should be able to start your registration process. Whether you must provide a full asset register during registration, and whether you can use the same for data processor and controller. Yes, indeed, you can use the same as data processor and data controller, but then a full asset register, no. What they mainly would want to know is the turnover of the business and the number of the employees and what nature of data that you process in your organization. That will help upon evaluation for the Office of the Data Protection to know what kind of invoices to levy on you or otherwise. And from Christine, where and how do you get information on data required by law to guide us on data minimization? Where and how do you get information on data required by law to guide on data minimization? Also give pointers and information on data storage as required by law. Again, I can just give this in a nutshell. For instance, you'll find that the Law Employment Act will give a period of up to 5 years for which you may keep personal data after separation. So in this case, for you to observe the principle of storage limitation, then if you are keeping employees' file up to 5 years after they leave, then you are not violating the act. But if you have a file 10 years later, then there is no lawful justification for you to be keeping that file, and that becomes against the principle of data minimization and storage limitation. Again, if you look for purposes of finance, for those who are in finance, again, there is a time that KRA can go and carry out an audit backwards. If you are looking at litigation, for instance, if it is an active file, you know, employees can go to court on employment matter within 3 years. Other matters could go up to 6 years. In short, you're saying you should have a justification. Ask yourself, if you do an audit in your archive today, ask yourself, why do you need that information there? Because that information is still harmful to people if it leaks, but yet may not be useful to the organization due to its obsolete nature. So again, Christine, this points you, there are several acts of parliament that may tell you when and how you can keep it, be it employment, be it income tax, be it what we call Limitation of Actions Act. All of them could guide you. And these are the things that should now shape your policy, because it should address all these concerns so that you give assurances that you will not be keeping data for a longer time than you need it. That being said, I don't know whether there is any other query that I may have missed, in which case I can respond to.
Thank you very much. I don't know if we have other committee members and the council member to make remarks from Mount Kenya region. Grace, our vice chair, and Kate, Madam Kate, the national vice chair. Anyone else with an oral submission before the 5 minutes are elapsed?
Mr. Ndengo, how are you?
Very well.
Okay, this is Isaac Boyd. This is the chair for Coast Eastern Branch. Sorry for, I just joined this. I think it's a good interactive.
Welcome, Chairman.
Thank you very much. So just a quick one to Mr. Peter. I think he has done, though it was a short while, he has done a good job. Only that I wish to understand. We have companies or other organizations that are, of course, like having inbuilt hospitals, and looking at how they normally do is whatever an employee registers as a spouse, and of course with the children, should be of course those who are recognized by the NHIF and what have you. So I'm not sure how this can be, because the company will, or rather the organization requests those information, probably to, it is a kind of control, because a cost implication on the company. I don't know how can this be approached based on what you had already given to us, Peter.
Thank you, Isaac. In this case, if, like, for instance, you intend maybe to control costs, and it is common, like, for instance, if you're running a medical scheme or even a clinic, it is normal for you to be told that maybe the policy covers up to 3 or 4 children, a spouse, and maybe up to 3 or 4 children up to this age. And in this case, it will be lawful and also transparent if you're telling your person that you will need information about 1, 2, 3, 4 for purposes of taking a medical cover, and that this information will not be used for any other information unless we come back to you and seek consent. That is the spirit expected by this act. It does not bar you from asking, but it ensures you ask in a transparent manner and give a commitment not to share without coming back for revised consent, or not only share, but even process or store, or any kind of processing to that information in a manner that may make the data subject feel uncomfortable. So yes, you may have in your policy, you're just committing to the people that inevitably out of this and this, we will need you to share with us this information. Then right to information, where do you need it? How will you store it? How long? How do you, all that is what is meant to give meaning to this, to the meaning, the spirit of this act of parliament. I hope that makes it clearer. Thank you.
Very well.
Yeah.
So
Thank you.
Thank you for the question, Chairman. However, we are very thankful. I have only 2 remarks to make before we close the Zoom. Number 1, thank you, Mr. Peter. Maybe you can share with me or with Grace or Mary the presentation. There's still another presentation you did on the 7th of March, which members are still asking for the soft notes on labor law. Secondly, for the Mount Kenya region, for the Mount Kenya North branch, we'll have a physical forum on the 11th of November, and to attend physically. Thank you very much.
Once again, thank you so much for having me facilitate for this region. I look forward to further engagement. Thank you so much and have a good evening.
Hiyo imenipita, anza share the training presentation. Nasema